Welcome to a brand new deep dive. Usually when we think about national security and international conflict, we picture military bases
Sure.
or maybe cyber defense command centers.
Yeah, or diplomats in high-stakes negotiations overseas. It's
Mm,
the classic imagery of geopolitics, right?
right. You picture the Pentagon, not like a suburban title office.
Exactly. It always feels very distant from our day-to-day lives. It operates on a level most of us just never interact with directly.
But today, the front line of national security might actually look a lot more like a high-end commercial real estate agency in downtown Houston or a mortgage lender's desk in Dallas.
Which is a structural shift in how we traditionally think about both international threats and private property.
Yeah, it brings the global stage right down to the local zoning level.
It really does. And it shifts the burden of policing those threats in a way we just haven't seen before.
And to understand exactly how and why that is happening, we are taking a deep dive into a very revealing stack of sources today.
We've got a lot to cover.
We do. We are looking at legal analysis from the Jackson Walker Law Firm, plus state press releases from Texas Attorney General Ken Paxton.
And we also have public policy critiques from Texas Policy Research and Texas Scorecard.
Right. Oh, and we've even got some branding material from a luxury Texas real estate agency, just to really ground this in the real world.
To show what it actually looks like on the ground.
Exactly. So, our mission for this deep dive is to unpack the newly proposed enforcement rules for Texas Senate Bill 17.
And, since you follow Texas policy, you likely already know the broad strokes of SB 17 from when it took effect back in September of 2025.
The one authored by State Senator Lois Kolkhorst.
That's the one. It's aimed at banning designated hostile foreign adversaries from owning Texas land. So specifically, we're talking about individuals and entities tied to China, Russia, Iran, and North Korea.
And that includes agricultural, commercial, industrial land, right? Plus mineral and water rights.
Yes, exactly. All of the above.
Okay, let's unpack this because what just dropped in late March of 2026 changes the entire game.
It really does. Having a law on the books is one thing.
Right, but actually enforcing a ban on international buyers requires this incredibly complex apparatus.
Yeah, you can't just wave a wand.
No, you can't. And these newly proposed rules, which were published in the Texas Register, they don't just outline a few minor paperwork changes.
Not at all.
They represent a massive controversial shift, and it directly impacts the private real estate industry. We're talking about sweeping new requirements that have the entire commercial real estate community paying very close attention.
Right. And to understand the sheer scale of these new rules, we really have to start with the concept of legal loopholes.
Oh, the workarounds.
Yeah, exactly. Whenever a government bans the purchase of a valuable asset, the immediate reaction from restricted buyers is rarely to just, give up.
Right, they consult their legal teams to find a structural workaround.
Exactly. They want to know how to execute the transaction so it doesn't trigger the statutory definition of a purchase.
They start looking for the back door. And the new proposed rules are clearly designed to bolt those doors shut. They finally put some teeth into defining incredibly vague statutory terms like ownership and control.
Well, the state knows that a restricted entity isn't going to just walk into a Texas broker's office and try to buy 100 acres of industrial land under the name of an adversarial nation's state-owned enterprise.
No, they'll use layered corporate structures.
Exactly. So they might set up a local Texas limited liability company. But that LLC is entirely owned by a Delaware corporation.
And Delaware is famous for corporate anonymity.
Right. And then that Delaware corporation is, in turn, controlled by an offshore trust. And that trust is ultimately funded and directed by an entity headquartered in one of the designated adversarial nations.
It's like Russian nesting dolls. But instead of just looking at the big wooden doll on the outside, the state is requiring the title company to physically break open every single layer.
Yep, all the way down.
Until they find the tiny doll at the center holding the purse strings.
That is the exact mechanism the state is attempting to enforce. The rules make it explicitly clear that ownership isn't just about whose name is printed on the final deed recorded at the county courthouse.
They're looking deeper.
Right. The Attorney General is targeting the substance of the transaction. They're looking at indirect control and ultimate beneficial ownership.
So if that restricted entity is pulling the strings from 5 corporate layers deep, it still counts.
It still qualifies as a violation.
Wow. But, controlling a property doesn't always mean buying it outright.
Right.
If the state blocks a sale, the next logical move for restricted entity is to just rent it indefinitely.
Which brings us to leases.
Exactly. And this is a fascinating detail the legal analysts at Jackson Walker highlighted, because the original SB 17 law actually has a carve-out. It allows for leases that are under 1 year.
The lease exception.
Right. So my question is, could a foreign company just sign an endless stack of back-to-back 364-day leases just to technically stay under that 1-year limit while effectively controlling the property forever?
What's fascinating here is that the state completely anticipated that exact strategy.
Oh, really?
Yeah. The commercial real estate industry has been asking about this nonstop since the law passed. Because, rolling short-term leases are a known tactic in other regulatory environments.
Sure, it's a classic loophole.
So the proposed rules provide a very firm answer. The state will look at the aggregate intent of the agreement.
Ah, so you can't just hit refresh on lease every December 30th?
No, you can't.
Mm-hmm.
The rules explicitly state that any renewal terms extending a lease beyond 1 year or any series of successive short-term agreements that effectively create a long-term leasehold interest are officially violations.
Wow.
Yeah, they are considered an acquisition of real property. They fall entirely outside the exception.
So the state is telling landlords, do not play games with the calendar.
Exactly. You cannot circumvent the spirit of the law.
That is a huge deal for the commercial sector because, as Jackson Walker points out, almost all commercial leases are longer than a year just for basic economic reasons.
Right. Think about a warehouse.
Exactly. If you are leasing a massive warehouse or office space, the landlord usually provides a tenant improvement allowance to build out the space.
Which is expensive.
Yeah, you can't amortize those construction costs over 11 months. So landlords and tenants are now going to have to heavily scrutinize how they structure these long-term arrangements.
Yep. If there's even a hint of a connection to an implicated foreign entity.
It fundamentally changes the risk profile of leasing commercial space in Texas. Every long-term lease now carries a geopolitical compliance risk.
Which sounds wild.
It does, but that brings us to the most critical logistical hurdle of this entire endeavor.
Who actually enforces it?
Right. If the corporate structures are designed to be invisible and the lease rules are incredibly strict, who is actually checking the paperwork to catch these foreign entities day to day?
Because you can't just have state troopers or agents from the Department of Public Safety knocking on doors across the entirety of the Texas real estate market.
Auditing every single land transaction,
Yeah.
there simply isn't enough manpower.
No, there isn't.
And this is where the rules take a truly dramatic turn. The state isn't just relying solely on its own investigators at the Office of the Attorney General, the OAG, to sniff out these deals.
Right. They are shifting a massive investigative burden directly onto private businesses.
They're establishing a category in the rules called facilitating entities. And that definition is incredibly broad.
It covers almost everyone.
It really does. Under these proposed rules, mortgage lenders, title insurance companies, property insurers, appraisers, and licensed real estate professionals, they are all now legally required to report any suspected violations to the OAG.
And the standard they are held to is the crazy part. They have to report it if they knew or should have known through reasonable due diligence.
Should have known.
That phrase, should have known, is the linchpin of the entire enforcement strategy.
Meaning willful ignorance is no longer a legal defense.
Exactly. A title agent can't just process the paperwork, close their eyes, and claim it wasn't their job to investigate the buyer's ultimate corporate backing. The state is demanding proactive scrutiny.
Let's ground this in a real-world example from our sources, because it paints such a vivid picture of how disruptive this is to standard business practices.
Let's hear it.
We reviewed the brand profile for the Legacy Group. They are a luxury real estate agency operating in Houston, Galveston, and Brazoria County.
Okay.
Very high-end, very sophisticated. Their brand values boast about having strategic intelligence and multidimensional expertise.
Fancy.
Right. They pride themselves on having these data-driven experts who can navigate complex deals and outmaneuver the market for their distinguished clientele.
So a firm that caters to high net worth individuals and international investors, providing a very seamless white glove service.
Exactly. But under these new rules, those sophisticated data-driven experts won't just be outmaneuvering the market, they will legally have to act as state watchdogs.
They're going to have to completely overhaul their internal workflows.
Imagine sitting across from a wealthy international investor trying to close a multi-million-dollar deal while simultaneously running forensic background checks on their corporate holding companies.
Right, just to ensure you don't have to report your own client to the Attorney General.
It's wild. It introduces a profoundly adversarial element into the client-agent relationship.
It really does. And, the legal analyst Jackson Walker pointed out something very striking about this specific mandate.
What's that?
This mandatory reporting duty for real estate professionals. It doesn't actually appear to be expressly required by the plain language of the original SB 17 statute.
Wait, really? So the Attorney General's office essentially created this private sector reporting mandate out of thin air during the rulemaking process.
Well, that is the core of the legal debate right now. The original statute passed by lawmakers bans the ownership and authorizes the state to enforce it.
Okay.
But the mechanism of forcing private entities like appraisers, title clerks, brokers to become the mandatory reporting mechanism, that is a regulatory addition by the OAG.
Wow.
It's a controversial expansion of the law's reach, and it places an immense unfunded new responsibility on the private sector.
Here's where it gets really interesting. Hold on. You're telling me the state can threaten a private business, like a title company, with massive fines or licensing referrals for not reporting a suspicious buyer. But how does the title company even know what to look for?
That's the million-dollar question.
Right. If an agent files a complaint about a suspicious buyer, what actually happens next? Because according to the sources from Texas Scorecard and Texas Policy Research, that complaint just disappears into a remarkably secretive process.
It enters a highly confidential investigative black box.
A black box?
Yeah. According to the proposed rules, complaints have to be submitted electronically or by mail to the OAG. But once the OAG receives them, the entire investigative process is shielded from public view.
Completely shielded.
Yes. All complaints, civil investigative demands, and background files are strictly confidential.
Wait, so the public or even the real estate agent who dutifully filed the report won't see any of the investigation?
Not unless it results in an actual lawsuit, a formal enforcement action, or if disclosure is otherwise required by law.
That's crazy.
The Attorney General is authorized to issue what are called civil investigative demands, which are essentially administrative subpoenas.
Okay.
They can demand emails, financial records, corporate charters, and they review all of this entirely behind closed doors. And they demand rapid compliance, often requiring businesses to produce these documents within just 7 days.
How is that fair to the industry?
It's tough.
The state threatens a title company with enforcement actions for failing to report a violation while simultaneously keeping the actual investigations hidden.
Right.
If you are an appraiser or a broker, you have to be terrified of making a mistake and missing a hidden foreign adversary. But you also have no public case studies to look at.
No transparent investigations, no detailed precedent to learn from, because the entire process is locked down. Well, this raises an essential question about the practical realities of compliance versus intelligence gathering.
Right.
The state would likely argue that strict confidentiality is absolutely essential for national security investigations.
Because you can't telegraph your moves.
Exactly. If you publicly announce you are looking into a specific shell company, you immediately tip off a hostile foreign intelligence service, allowing them to destroy documents or shift the assets.
Well, that makes sense.
Plus, you want to protect the privacy and reputations of innocent buyers who might get investigated just due to a false alarm from an overly cautious real estate agent.
That does make sense from a counterintelligence perspective. You don't want to ruin a legitimate domestic business's reputation just because an appraiser misunderstood a complex corporate structure and flagged them.
Right.
But for the industry, the stakes of getting this wrong are absolutely staggering.
They are brutal.
Yeah.
The enforcement mechanisms are designed to be punitive enough to act as a severe deterrent.
So what are the actual penalties?
If a violation is confirmed, the courts can order the forced divestment of the property.
Meaning the state legally forces you to sell the asset, likely at a massive loss depending on market conditions.
Yeah, and that is just the beginning. The civil penalties are astronomical.
How astronomical.
The penalty is either $250,000 or 50% of the property's fair market value, whichever is greater.
Whichever is greater. Wait, 50%, that's huge. Think about the math on commercial real estate in Texas.
Do the math.
If a restricted entity illegally buys a $50 million industrial complex near a port or a logistics hub, the penalty isn't just a slap on the wrist, it's a $25 million fine.
Yep.
Plus the forced sale of the property. Plus potential criminal liability for knowing violations.
It's catastrophic financial risk.
Which is exactly why title companies and commercial lenders are going to be so hypersensitive, they might just refuse to underwrite deals that seem too complex.
And that chilling effect, that hypersensitivity, is exactly what brings us to the broader philosophical and economic collision at the heart of this entire deep dive.
Let's talk about that.
We are looking at two distinctly opposing viewpoints present in our sources regarding the ultimate impact of these rules on the state of Texas.
Let's look at those broader implications, and we'll make sure to present both sides impartially based on what the sources provided.
Good idea.
On one side, you have the perspective championed by Attorney General Ken Paxton. His stance, as quoted in his official press release, is pretty absolute. He says, "My office will use every tool available to prevent our nation's enemies from gaining a foothold on Texas soil."
The focus there is squarely on mitigating severe national security risks at the state level.
Right.
The argument is that adversarial nations are actively executing long-term strategies. They want to acquire land near military bases, energy grids, and critical supply chain infrastructure.
So from this viewpoint, the strict rules, the mandatory private sector reporting requirements, and the severe financial penalties are just a necessary, non-negotiable defense mechanism.
Exactly. To protect the state from hostile foreign actors attempting to exploit the open market.
It prioritizes the safety and sovereignty of the state's physical resources above all else.
But on the other side, we have the perspective outlined by Texas Policy Research.
Right. They're a public policy organization that strongly opposed SB 17 during the 89th legislative session.
And their concerns are rooted deeply in free market principles and the practicalities of a globalized economy.
They argue that the law, and especially these aggressive new proposed enforcement rules, fundamentally infringe on private property rights and disrupt vital economic activity.
Texas Policy Research points out that by relying so heavily on private sector reporting and by using such incredibly broad definitions of ownership and control, the state is creating massive, perhaps insurmountable, compliance burdens.
Right. They argue this reaches far beyond straightforward land purchases by adversarial governments. Instead, it tangles up complex, entirely legitimate commercial transactions in government red tape.
Think about it from an investor's perspective.
Exactly. A legitimate investment fund from an allied nation might look at the forensic auditing required to buy land in Texas and simply decide to take their capital to a neighboring state to avoid the hassle.
If we connect this to the bigger picture, this is a classic high-stakes collision of core values. Texas is a state historically defined by its fierce protection of private property rights and a vigorously free market, business-friendly environment.
Don't mess with Texas applies to government regulations dictating who you can sell your property to just as much as it does to anything else.
Precisely.
Yeah.
But Texas is also prioritizing a localized approach to national security.
Right.
And when the goal of keeping foreign adversaries out of the local real estate market collides with the goal of keeping the real estate market free from state interference, you get the intense friction we are seeing in these proposed rules.
The state has decided that national security threats require compromising the traditional ease and privacy of private property transactions.
Yeah, that's the trade-off.
But, it's not a done deal yet.
True.
To summarize the current timeline for you, based on the sources right now, these rules are just proposals.
They're not final.
Exactly. The public comment period is officially open. And stakeholders from luxury real estate agents in Houston to commercial lenders in Dallas have until April 27, 2026 to weigh in and voice their concerns.
And after that window closes, the Attorney General may adopt the rules, turning them from a proposal into the binding official framework.
Which means the entire real estate industry has a very short, very stressful window to figure out how to adapt their operations to this new reality.
A very short window.
So, what does this all mean for you? Whether you are a commercial tenant negotiating a long-term lease, a landlord structuring a new development, or just someone fascinated by the intersection of international geopolitics and local law, the landscape of buying and leasing property in Texas is about to require a massive amount of scrutiny.
It really is.
The days of simply checking credit scores, verifying funds, and signing a deed are over. The background checks are going global, and the liability is resting squarely on the shoulders of the local professionals handling the paperwork.
It's a heavy burden.
Yeah. Keep an eye on that April 27th deadline, because the rules of the game are changing incredibly fast.
And it leaves us with a fascinating dynamic to consider as this plays out.
What's that?
If local private real estate agents, title clerks, and appraisers are effectively being deputized by the state to fight international Cold Wars, auditing corporate shells to uncover hostile foreign intelligence assets, at what point does the primary responsibility for national security permanently shift from the federal government down to your neighborhood real estate broker?